The Ministry of Corporate Affairs has published a draft of the amendments to the competition bill seeking comments from the public. Now, as you may know, competition law is pretty important because all the major businesses come under the ambit of the antitrust regulator, that is the Competition Commission of India or CCI. Now, the CCI also regulates companies for anti-competitive and anti-consumer practices. On the face of it, the draft Competition Amendment Bill 2020 appears to be a big step, potentially bringing in procedural and also regulatory clarity and making it easier for companies to also do business in the country. Joining me to help us understand the significance of the proposed changes is Mr. Ram Kumar Poornachandran, partner, TT&A, which is a law firm. Now, Ram has also been long covering the competition law and also has some big ticket clients as well. Let me begin by understanding and asking you, what are the big proposed changes, or if you could just name top 3 proposed changes to the competition bill?
Yeah, sure, Sakshi. At the outset, I should state that the draft amendments are largely a step in the right direction, and this is going to significantly overhaul the Competition Act. So that is a very important step. However, there are certain areas of concerns that is being discussed widely amongst the industry, which I'll talk about in a minute. As far as the key developments are concerned, the introduction of settlement and commitment mechanism is a very important step to my mind, because this enables the parties who are being investigated by the Commission to admit the anti-competitive conduct and come to a settlement with the authority.
Right.
And this, in a way, reduces the number of years that they would be stuck in front of the Commission, and this saves a great deal of time and money and resources, both from the company's perspective as well as from the Commission's perspective. So that is a very important step.
Right, absolutely. Now, recently, Ram, I wanted to understand a whole lot of companies like Make My Trip, Ola, Amazon, Flipkart, they've actually come under the lens of CCI as well for allegedly indulging in anti-competitive prices or practices. I just wanted to understand, how do things change for these companies from here on, and do these proposed changes, change the way they are regulated from here on?
So these draft amendments are not targeting any specific set of companies. These have been on the pipeline for a very long time and doesn't have a specific impact on the tech or digital companies, except for the only fact that I can think of is from a merger control side. So the government now proposes to introduce a specific set of additional criteria. If those criteria are met, a certain type of transaction will be reportable to the Competition Commission of India. So it is broadly understood that these additional criteria are kind of formulated to attract or to grab transactions which were previously slipping through the cracks. Indicating that these are the transactions happening in the technology and digital space, which the CCI did not have jurisdiction over previously.
Correct.
So that is the only way I can think that this would have an impact.
Right. And what about the end consumer who is actually affected by these kind of antitrust or anti-competitive practices? What happens to them? Will these proposed changes impact them in any way?
The Competition Act itself is to enhance consumer welfare. So this is going to indirectly make bring out a lot of difference in the market, which is going to have a impact on the end consumers. But directly speaking, the settlement and commitment mechanism, which I suggested, when a company agrees to settle a matter, what would happen ideally in another mature jurisdiction is settlement will lead to finding of violation, which will expedite the pace at which the compensation action will be initiated by an aggrieved consumer or a customer. So that is an important development from a consumer perspective.
Absolutely, right. Now, Ram, there's one more important point. Recently, we've seen many debates happening around the need for competition, the need for level playing field, also the role of the competition regulator, the CCI as well. Do you think these proposed changes will empower the CCI to be more transparent, to create more efficiency in the system, and also to efficiently deal with the new age issues that are erupting right now?
I definitely feel that this overall is going to enable the CCI to work effectively, particularly in reduction of timeline, both on the merger control side and also on the antitrust side, because Commission often was being criticized that it takes a very long time to kind of clear transactions, because reduction of timelines on the merger control side is definitely a very, very good step, and it's a very progressive step. And yes, it is going to enhance transparency and enable the Commission to work more effectively.
Right. I also wanted to ask you about about the proposed change on the organizational front. There have been some changes there. So the composition of CCI will also be changed if these proposals are accepted. Now there'll be 7 CCI whole-time members, 4 part-time members will also have to be inducted, and also there'll be 2 government officials as well. Now, given the fact that the commission also governs or has a jurisdiction over government enterprises as well, do you think the involvement of 2 government officials will in any way compromise the autonomy of the commission?
So that, as I mentioned at the beginning of the discussion, that is one area of concern. I would say there are 2 or 3 sub points to that. The first one is the draft amendments provides for a governing board, which, as you've rightly mentioned, provides for 2 secretaries to kind of participate in the affairs. So there is a kind of a broad question arising in the minds of the industry folks, that if that is going to affect the independence of the functioning of the commission. And another point is that the draft amendment provides for the Director General of Investigation to be now appointed by the CCI, who was previously appointed by the Ministry of Corporate Affairs.
Correct.
So would that affect the independence and the functioning of the Director General? So whether it would affect the independence and like whether CCI is going to have a more intrusive role, or it's going to kind of affect how the investigation is being carried out. That is another area of concern.
Absolutely. But overall, if we talk about the kind of changes that have been introduced or proposed, about 45 changes have been accepted so far out of the 50 changes that were proposed by the committee as well. Do you think this will overall have the give the much needed clarity and robustness to the entire regime or the competition regime, or still much needs to be done?
So, like any other law, this is a dynamic piece of work, and I mean, this draft amendments, if given effect to, is going to definitely bring about a lot of clarity, and it is going to kind of enable the CCI to effectively perform its functions.
All right, thanks a lot then, Ram, for sharing all these insights over there. With that, we hope that all these amendments bring about the much needed clarity, transparency, and also efficiency in the competition regime. Thanks a lot for joining in.